follow your
I didn't
lead.
get to shake your
No, we
hand.
got,
Nice.
so we have a quorum, you might as well
Well,
start.
let's
follow,
go.
we follow the chairperson's lead.
Well,
Mr. City Manager, we're ready to start.
okay.
Absolutely. Well, I'll go.
She's the
Okay.
chair.
All right.
She's supposed to start it out.
Okay, well, let's start it.
Okay, I just learned today I'm the
All right.
chair, so I'm not being bossy.
No,
but-
no, no.
Okay. Good evening, my name is O.V. Brantley, and I have recently been appointed by Mayor Bill Evers to be colleagues with you on this ethics board. And I learned today from reading the code that the mayoral appointment is the chair of the board. So that's how I get to be chair. I have to admit that I came prepared to absolutely say I will not be the chair on the time constraints. But I'm sure, looking at this group, that y'all will make my burden easy. So with that preliminary, I should say I'm calling the meeting to order. And I'm going to turn it over for our welcome to the city manager.
Well, thank you very much today for kind of serving in this capacity. Excited to have a great group of you guys who decided to kind of take on this very important role on the board. I'll just tell you that as a city manager, just based on the ordinance, I'm simply here to give you staff support and overview of the different topics that are on your agenda. And then if you have any questions, if my office or the clerk's office is able to answer them and provide you insights, we will also, if you desire things like training and, different equipment that may be needed for the meeting, like the recordings and things of that nature, you would just flow your request through us, and then we work through the council and the budget office to make sure you get what you need. So with that,
Thank you. Following our agenda, I'm going to ask each of you to introduce yourselves and maybe just tell us one or two lines about yourself. I guess I will start off just by saying that I am a lawyer. My whole legal background has been in local government law. I'm a former Fulton County attorney, DeKalb County attorney, Hall County attorney, and East Point City attorney. So that's kind of my background, but I've always been on the other side of the table and not this side of the table. So if we could start on my left and move down the table.
Okay. I am Charles Ivers, and I am an attorney as well. I happen to work for the state of Georgia at the Department of Corrections. I do primarily contracts. Spent some years as a litigator, civil and criminal defense work. Happy to be here.
Thank you.
My name is Kenneth F. Joe Sr., and I was appointed by Carmelita Gomes, District 2. I am a consultant. I do lobbying work. I've worked in public and private government as the Fulton County DFACS Director, the Chief Administrator for DFACS, the Richmond County DFACS Director. So I have quite a extensive years of experience in public government. So that's me.
Great.
Hi, my name is Jill Pope. I'm from District 3. I'm with my councilwoman, and I'm an attorney in the Metro Atlanta area.
Thank you.
Hello, my name is Calvin Bennett. I'm from District 5. I'm a long-time business owner here in College, State College Park, South Fulton, over 20 years. I have a degree in a master's degree in legal studies because I just couldn't get it together to take that LSAT. I've always admired attorneys. I'm a former candidate here for District 5 also. Just decided to work with the winner, and it was Rosie. So here I am. She appointed me on board.
My name is Jewel Johnson, and I've been a community activist in South Fulton for over 40 years. I'm a retired nurse that has many interests, but most of my interest is mainly the people. I was appointed by Councilwoman Gilliard from District 4.
Good evening, Dennis Francis. I'm with the State of Georgia Public Defender Council, so I'm a lawyer also. Director of what's called the Metro Conflict Defender's Office. It's a public defender agency for when there are more than one person charged in a crime here in Fulton County. and I come through District.
Okay. Well, welcome, one and all. I do understand this is our inaugural meeting. So part of what I hope we will do as we proceed down this road toward becoming the world's greatest ethics board ever, and we will get to know each other. I believe that knowing people makes it easy to respect their opinions, and I hope that will be my approach to running the board, that we try to get to know each other so that we can respect each other. Since this is our inaugural meeting, we're going to have, according to the agenda, a discussion on general organization. I believe the county manager, Mr. Donald, has some points that he would like to cover with us.
Yes, very, very much so. Thank you very much for that. You guys have received your packets, which include all of the relevant ordinances and other supporting documentation. And so I just wanted to kind of highlight a variety of key points and lines for you in lieu of formal training, just kind of an overview. I know that many of you are advanced and of course understand the laws and rules and regulations, but just wanted to highlight those. So the initial ordinance that implements the overall ethics board is ordinance 2018-052. It provides the guidance related to operations and administration of the board. There are a few general sections that I just wanted to highlight for you. Section 1-5006, line 228, assigns the chair as the appointee of the mayor. The board chair has no vote unless it is needed to break a tie. Section 1-5006J, beginning at line 274, it assigns the city manager to provide staff support as well as the city clerk for recording and retention support and services. Section 1-5006K, line 290, provides the overall authority of the board, making it known publicly and legally that you have the authority to operate. Section 1-5007, line 300, provides guidance on how to handle a complaint, including the processes of the city. As you know, the city has 2 days upon receipt of a complaint to ensure that it is provided to the ethics board of the city of South Fulton, the city manager, the city attorney, the mayor, and the full council. In section 1-5007, line 333, it provides guidance on the requirements for the preliminary review and hearing. And in addition to that, ordinance 2019-11 amends Title I. Title I is the actual initial ordinance that I was just referring to, but the ordinance 2019-11 amends that title, and it actually addresses outside proceedings and their impact on the ethics board, beginning with line 37 of section 1-510. It also restricts complaints that arise from failed court proceedings from being admissible to the ethics board, which is specifically addressed in lines 39 and 40. So just high-level overview of the ordinance and the additional amendments to the original ordinance for your overview. I do understand that you had time to read and review those materials, but just wanted to provide you a general overview of that process.
Okay. I think this might be a good point to sort of open the floor to suggestions on organizational issues and how we should proceed. I do want to just reiterate one point that he made, is that I don't have a vote unless there is a tie. But what I would like to get your input on. I think it would be beneficial to all of us if we were to find time in our schedules to have what I'm characterizing as a small training session before we move forward taking up any complaints. I know that GMA has people on staff or could help us find somebody who could come and talk us through general ethics law. I am very concerned that we're all very up to date on the open meetings law. And just so that we have the same body of knowledge. We're all very intelligent people on this board. Everybody knows, they have their idea of what ethics means. I may have my idea, but I think it would really make it smoother going forward if we could be trained and then move forward. And just another thing down the road, just for you to be thinking about, at some point I do think that this board needs to adopt its own procedures. You know, the ethics code is very general, but most bodies will have internal operating procedures as to how the body wants to operate. So I just wanted, while we're talking organization, I just wanted to put those two things on the table and then hear from anybody else who wants to suggest how we might go about getting ourselves organized and ready to go to work.
Madam Chair?
Yes.
I think that's a great idea. However, I think that in this particular case, that we could settle this particular complaint because the emergency amendment speaks very clearly that any complaints arising from court proceedings cannot be considered an ethics complaint. So thus, I don't think that based upon the emergency policy that's right here, that we have any authority to hear this complaint. That's as far as the complaint is concerned, and I can read that if you want me to.
I think has everybody read the...
Okay. Oh, okay.
Okay.
So I think that we could settle the complaint and then look towards training. I think that would be a good idea. But I don't think that there is any reason to delay the fact that this is not a valid complaint based upon this emergency policy amendment that's put here.
Madam Chair, I happen to agree with his assessment.
Anybody else? On organizational issues.
I like the concept of sort of creating procedures and how we, this is the first time for me, how we go forward. But I will say in response to Mr. Joe, my reading is that this complaint has 2 charges to it. So I'm not sure if we can resolve the entire complaint based on the amendment that came down that I received today. There's a second part to it.
But even in that part, isn't it true that's the part that the ethics board wouldn't have a party, and that's more or less a court proceeding?
No, that's the first part, right? The first charge in the complaint would be related to a court proceeding. But the second part is related to the specific ethics code.
So obviously we got some disagreement on that, so
I'm
that takes it there. But I tend to disagree with that, sir, only because it all comes from the same tree.
I understand.
So if it comes from the same tree, the thing is, you don't break that up. I mean, you're an attorney, so I think, I mean, I know you know that. It all comes from the same tree. So I don't think there's two separate, per se, or 2 separate issues. I think that there's 2 breakouts of the same issue that has come from the same tree, but that's my opinion.
Madam Chair, would you mind?
Well, let me see if anybody else wants to make a comment on organizational issues. I was really trying not to get to the
I like
complaint.
what you put forward, the training. I think that's good.
Anybody else want to say anything about organizational? This sort of, if I may, this sort of touches on the complaint, but also organizational. One reason we may I say may because I just got appointed and I haven't studied everything, but we may not want to proceed tonight is because I have a little unreadiness with the amount of time the agenda was on the street. I don't think under the Open Meetings Act, whether it says so explicitly or implicitly, to take action on a complaint when the public didn't know that we were going to take action tonight. I mean, I saw the agenda for the first time today. Maybe it was somewhere else.
And
Was
correct
it somewhere
It was
else?
posted.
Correct me if I'm wrong.
Okay,
but
well,
my-
maybe I'm wrong on that.
but
I
my
didn't see
re-
it till
but
today.
My reading of the procedures is we're to have a preliminary hearing.
Well, and that's one of the reasons we need to clarify our
Right.
integral
Right.
rules.
I agree.
Because what do you mean by a preliminary hearing? And is a preliminary hearing a question that I had really necessary if the issue is jurisdictional? And I think that's what we're struggling with here. When we get to the complaint, is it's a jurisdictional issue. Can we even hear it? And so does the preliminary hearing kick in on a jurisdictional hearing? I know in regular court, the court doesn't have jurisdiction, that's it. The court rules you don't get to any kind of hearing. But we need to have consensus on how we're going to proceed on those kind of technical things. I believe that if we, this probably won't be the most difficult complaint we've ever had. So just personally, I don't feel like we have to rush. But that's just, well, any other organizational things? You know, we will always assume that everybody comes to a meeting prepared and having read the materials. And am I correct, I may have missed this in your presentation, Mr. Donald, but we would look to your office to give us all the materials that we need to be ready for the hearing?
Yes, in conjunction with the clerk's office, and I think that's just the point that I wanted to interject to you. One, the clerk is the record keeper and record holder for the city, and so all of these documents would be gathered and either provided to you directly from the clerk or provided to my office to do so. Your internal rules would really guide that because the ordinance is fairly silent on it. It just says that we provide support, they provide the records, and how you would like to receive them. Your processes would determine that. I think secondly, I heard the mention of training that you would desire. And so if you would desire those things as well, I don't think it takes a formal vote. It's just that when you come to consensus as the chair, you can simply request it. And if it's in budget, we just automatically provide it to you. If not, then we take it to the council and then they approve it and we provide it. So I just wanted to let you know that your request on whatever you decide, you would just simply provide it to us and we do the legwork on your behalf.
All due respect to you, City Manager Donald, and I think, you know, the way we started out really was totally out of order. Because when you read the ordinance, and I don't mean no harm and no disrespect to you, okay? It really was supposed to mean start basically with you. This is an independent, non-paying group here. Okay, and you as the chair was supposed to initiate everything. Mr. Downhill, we appreciate him and everything that he brings to us, but he has nothing to interject. You are in charge, and we're your team players, and we're gonna work with you.
Well, thank you for saying that you're a team player and you're gonna work with me. I've been appointed for 2 days, so personally, I thank Mr. Donald for helping me out in this first meeting. Thank you very much. But I agree with my colleague here that we are an independent board, and which is why I want us to spend a little time figuring out how all that works between us. Because we're 8, I can already tell independent people. So duly noted, duly noted. we'll get it straight. Get ourselves straightened out.
So I have a question. There
Yes.
was an amendment that went out today. You said that there was an amendment.
I had an email, and it's the emergency ordinance to amend Title I.
Oh, okay. There wasn't an amendment, there wasn't any, okay. I thought you were meaning
Oh,
to
I misstated then.
Okay.
I apologize.
to the complaint.
No, not an amendment to the complaint, but the complaint is clearly separated into two different charges.
Okay.
One other thing that I would like to say organizationally, the code does say that we're governed by Robert's Rules of Order. I would prefer if we can be as less formal as possible while still keeping order. It will be my intent to recognize everybody who wants to speak and try not to cut off any kind of discussion until everybody has an opportunity to speak. Of course, on recorded matters, we have to do motions and seconds and actually vote. But I brought my Robert's Rules of Order tonight. I'm not sure we all have some familiarity with Robert's Rules. But if we can function and get our business done by being respectful to each other without hyper-technicality, I hope that we can do that. That's just something that will unfold as we go forward. But we just want to get everybody's opinion, get everybody's questions answered, and reach a decision, and not get bogged down too much in Robert's Rules. I think those were the only organizational points that I wanted to make. Did I miss anybody who wanted to say anything about how we should move forward, getting ourselves organized? Ms. Johnson?
One thing that I would, and this is just me, everybody don't have to agree with me, but I'm sort of a obsessive compulsive type person for time. And if we are supposed to meet at 5, then I want to be here at 5. Usually, normally I'm at least 15, 20 minutes early. That's just me, and I wanted to make sure that we're going to move on time, and hopefully everybody else will be able to do the same thing.
I think that we can all agree that we want to start the meetings on time, and that anybody who is running late because life does intervene would understand that we have to go ahead and get started. Is that agreeable? That we'll start out trying to be on time and be respectful.
Anything might happen.
Right.
But ordinarily,
That's a good point.
we need to be on time.
Yes.
I absolutely agree with that, Jewel, and I think we need to stay true to that on the other end as well, as far as being efficient with how we go about our business, that we are not going down avenues that we should not go down if policy clearly speaks to that, that we are to respect each other's time by doing our homework before, and accepting the fact that despite our own beliefs, we have to go with whatever's written in policy, even if that doesn't agree with what we state.
Those are very good points. Okay, so that's a good segue to ask Mr. Donald. I think he had taken it up on himself to be familiar with the complaint. Obviously, in this situation, we don't have a city attorney who would brief us or summarize, or however it is we would like to receive the information that we're ultimately going to vote on. Go ahead.
Mean no harm. But we on our own. We love Mr. Donald,
Well, you're not
but
on your
we
own.
need to do our own thing.
Can I make this suggestion?
Yes.
Because I'm still a little unclear, and you have more experience than I would. But as I read the ordinance, we have the ability to dismiss, no question about it. It sets out the framework how we dismiss. but it says we dismiss after a preliminary hearing. That's my issue, because we don't want a situation where there's pushback and they say, hey, you guys didn't do it properly. So maybe if I'm reading it incorrectly, you'll let me know, but it sets out how we dismiss. And we
Everybody
can
go to that and read it and
Right.
see if y'all agree
Right,
with him.
and we can dismiss based on the new ordinance, no question about it. But I don't think we can dismiss, but you said there's a jurisdictional issue, but where would that be laid out as the procedure that we can follow? So that we don't have, there's not litigation later on for us not doing something properly based on what's written here. That's all, that's my only question. And I guess we can vote on what we do, but we need to do it as a body. Because on page,
What page is that?
what page is that? That's section 15007 under complaints. Under dismissal, subsection B, it lists how the complainant can dismiss by withdrawing and how the board can dismiss. And those are subpoints 1 and 2. But then section C indicates our procedure and how we go about implementing our power in subsection 2.
I made notes on all this.
Chairwoman,
Yes.
before you move on to this item, I wanted to know, I heard you guys mention the things that you would like from the city that included training, and I think you mentioned your procedures. For the record, it would probably be good, because you will be producing a record from this meeting, to either formally request, and I don't think it's a vote required, but it would be good that if you have consensus that you want additional training, not related to the complaint, but just in general, as you guys suggested, you would just formally make the request of the city to coordinate that and provide it, so that we can have it for the record and put that in place for you. Again, if you decide to move on or not move or whatever for the ethics piece, again, we want to make sure that we provide it. I know that Ms. Johnson has been
Yeah, I'm gonna hit your
quite,
hands.
please let me finish, ma'am. I think that she's been very open that you're an independent board. I think my emails and correspondence have provided that. I think it's also clear in the ordinance that the city is here to provide you your staff support. And as your staff support, if you have a request, I want to make sure that we capture it so that we can give you all the tools that you need to act independently. And so if you believe that training is one of those things, I thought I heard some other things, but it was not formal. And so we want to make sure, again, before you move on to another item, that you get exactly what you need.
Okay. Board members, we are still on organization, and we had talked about training. Could I have a motion regarding whether we would like for the city to assist us in arranging, scheduling a training session? Possibly through GMA.
Well, I'd like to
threw
make that motion that we adopt that for the assistance of the training, or whatever whatever the board may decide. It may not be GMA, it might be you doing the training, just whatever.
So state your motion that the board that desires to be trained, is that?
Right.
And we
right.
will decide what that training will be.
Right.
And is there a second?
Second.
Okay. It's been moved and properly second that the board will take whatever steps we deem necessary to be trained in whatever we decide we want to be trained in. All in favor?
Before we say the aye,
Mhm.
one other thing I want to say. I would not want the training to hold up what we need to do with this particular claim. Okay.
Okay. There's a motion on the floor. Any other discussion? All in favor, say aye.
Aye.
Okay. So we will figure out what type of training we want to have, and I will communicate with each of you and try to get an idea about scheduling and that sort of thing. Regarding, we're back to the actual ethics complaint.
I'm sorry, Madam Chair. Just for the record,
Yes.
I'm just advising that you close out that vote by asking if there is any nays.
Thank you.
No problem.
Okay. I thought it was unanimous, but
Even if it is, you need to ask it.
are there any nays to the motion we just voted on? Okay, hearing none, the motion is carried. Thank you.
Can I ask you one question?
Yes.
Who's keeping minutes?
Yeah,
Clerk's
I was,
office.
yes, I was going
Recorded
to.
as well as written.
I'm glad,
Okay.
because I was gonna bring that up, that, you know, we're an independent board, but we need support, and we don't wanna be bowed down by having to keep records of the meetings, and, you know, I'm just making sure that the clerk's office is, I was gonna say that. We're not trying to push everybody out, we just don't want interference. Is that about right, Ms. Jewell?
That's right.
Okay, all right.
Okay, moving on the agenda. May I assume that everybody has read the complaint, or would you like for the manager, or would you like a summary? How do you want to proceed on dealing with the complaint?
I keep saying this, but don't take it personal.
I don't take anything.
Okay. But I keep going back, we're independent, okay? So everything that comes out needs to be from this body.
Well, let me push back a little bit on that.
Okay,
Okay.
go right ahead.
Every board, every citizen board that I have ever seen operate had support from the governmental staff.
Right.
And the way I see it is that Mr. Adams and Mr. Donald are here to support us. We don't want to do clerical work. We don't want to do errands. We don't want to make copies, you know, that sort of thing. But, because we're all very busy. But clearly you are correct. When it's time to make a decision about how we proceed, what we decide, then we are totally independent, and staff does not have any input into that.
Now, can
But
I
I'm
push back a
not,
little?
but I'm not clear. This is why I think we need rules, internal
Right,
rules,
right.
because I'm not clear on what the city attorney's role would be in a normal, you know, in a normal kind of complaint. Most ethics boards that I'm familiar with have somebody who presents the case.
Presents a summary
Yes.
of the origination of the complaint and the facts, that without injecting opinion
Correct.
or assumption.
And I think that's all
And
Mr. Donald.
I know that's what Jewel is concerned about, and I am as well. But I would I would say to you, Jewel, I completely understand, and I'm hyper vigilant about that as well. And what I say is that we trust that it will be presented that way
Okay.
until we have reason to think otherwise.
Oh,
Is that fair?
that's fair, I just didn't
No,
want to go that way.
I think that I think that pushback in the beginning to make sure that everyone involved understand that we are going to adhere to the integrity of the board's independence
Yes.
going forward.
Yes.
Knowing that we have to have some level of trust that we will not be unfairly influenced by any staff that we have to depend on to provide support to us.
Right. And we don't mean any harm.
No,
To anybody.
absolutely not.
I respect people where they are, and I accept them where they are. But I just wanted to be very clear that nothing is going to be interjected there to influence my decision or anybody else on this board's decision.
Okay.
So, Madam Chair,
Yes, go ahead.
so with that being said, I think that, I don't know if, I just make a suggestion, I don't think it have to be as a motion, and it's your decision as chair, that I think we should move forward with letting the city manager, in lieu of a attorney, who would, I think, give us the summary, a summary as to the origination of the complaint and how it was presented. So, I mean, I've read it, but I think it would be good for us all to hear it at the same time, maybe.
So, from me reading this, the only thing that we have to do today is determine whether or not we're going to dismiss it or go for a formal hearing.
I believe so.
I'm correct?
I
Okay.
believe so.
So,
Preliminary.
I'm not sure if, I think, Madam
Okay.
Chair, let me suggest this, that we first vote on our procedure, as you've been saying, that we pick a procedure, because my reading of this, and if I'm wrong, let me know, is that we have to have a preliminary hearing. And if we have to have a preliminary hearing, we have to give 10 days notice to both sides, so that they can appear, and they get 10 minutes each side to state as to why it shouldn't be dismissed. If that is correct, if I'm wrong, let me know. If that's correct, then what happens if we go forward on this complaint and we have not done that procedure, then we have been in violation of what's written here. But if I'm wrong, please let me know.
that's, yeah, because it says within 30 calendar days of the board's receipt, the board
Right.
shall make a determination at a preliminary hearing
Right.
as to whether the complaint shall proceed to a formal hearing,
Right.
subsection 1, or 2, be dismissed on the grounds that it is non-compliant with the requirements of the chapter,
Right.
unjustified, frivolous, or patently unfounded. So, or fails to state
Right.
facts sufficient to invoke the
Right.
disciplinary jurisdiction of the city council. So that's today. We're doing our review. That's today.
Correct.
Am I correct?
Correct.
Yes.
I think if I
Correct.
go through these talking points, it'll make it much easier.
Yeah.
Okay.
And if you
And I-
right.
Okay. He asked,
So I made a
If I'm
suggestion.
wrong,
Mr. Joe, can I go back to ordinance official? Are we first name and last name basis? What do y'all, how would y'all like me to address it?
Yeah. So, yeah, I mean, if I'm wrong, that's fine. We can go forward.
Okay, I'll ask y'all that after the meeting. There was a suggestion by Mr. Joe. Joe is your last name?
Yes, ma'am.
Okay, by Mr. Joe, that we allow the county, the city manager to present to us an objective summary of the complaint. Do I hear any opposition to that at this time? Joe?
As long as our city manager addresses it in the form that it's supposed to be in, and he's not self-injected anything.
Oh.
Because if he is, I'm gonna stop it.
Agreed, agreed.
Okay, so we are agreed. You have the floor,
All
Mr.
right.
Downs.
So, not necessarily a summary of the complaint, just of the process in which we receive it and how I would encourage you to review. And so, you've received ethics complaint 2019-01. Your packet includes this first official ethics complaint. It arises from a recent court proceeding. And so normally in compliance with the ordinance, the city attorney is usually present to provide legal advice, but due to the nature of the complaint, it would be a conflict of interest. I am not a lawyer and in no position to provide any legal advice. And so I simply encourage the board to discuss the complaint filed and notify myself and the city's clerk office if you have any, if you can't come to an agreement on actually what the legal process should be, you could actually request from us some additional legal support, third-party legal support. And if you need that, then we could provide it. And so those are my talking points in relation to the ethics complaint that you have in front of you, and I encourage you to have discussion among yourselves. Thank you.
Thank you, Mr. Dunn.
Got it.
Okay.
More than
All
welcome,
right.
Ms. Johnson. I operate the same way 24/7. So you
I
should
want
not be
to
surprised.
open the floor for discussion on whether we are required to have a preliminary hearing or whether the complaint is ripe for action tonight.
I lost the last part of what you said. You mind?
We need to resolve what Mr. Francis is saying. Is a preliminary hearing required, or is this board empowered under the ordinance to dismiss, to take action on the complaint tonight? I thought I heard differing views on that, so let's see if we can hash that out. Yes.
Madam Chair, as I stated earlier, I think that the amendment, the background I come from in child welfare is DFACS is ruled by a lot of different policies. And there's this, what you call, whether or not a abuse allegation is substantiated or insubstantiated. Now, that's if it gets to the investigation piece. Before it gets there, there's a thing called screen out, meaning that it doesn't rise to the level in which an investigation should proceed. I think, and it's just the way I'm reading this amendment, is that based upon this amendment, as far as outside proceedings, section 150010, it clearly speaks to the fact that that this forum shall not be used to file ethics complaints that arise from court proceedings, period. And so if that is the case, I think that that does not go to any type of official forum. I think that it has told us that it should not be heard. But I hear that we may not all agree with that, and I just make a recommendation, Madam Chair, that we get we ask the clerk's office or the city manager's office to get more advice on that from us from a legal standpoint.
Advice for us?
Yes,
Okay.
since there seems to be some disagreement of whether or not this speaks to the fact that we should not proceed to a preliminary hearing, or if we should proceed to a preliminary hearing. Because if the amendment means what I said, what I think it says, it means that we don't proceed to a preliminary hearing. And so I'm asking to get some clarification on that.
Can I?
Yes.
I agree with him totally. This is our first meeting, and it's because our attorney is involved, it's kind of like makes it a little bit more challenging. And I think that we need to have an attorney here to advise us, someone that's, ethic like in her place. I don't know, that's like he said, he wasn't a lawyer, but I think the city should give us an attorney who's qualified to answer these questions. Just like Mr. Francis stated, we can make decisions, and if it's not within order, it'd be thrown out and we put the city at risk, with liability.
Other comments?
Yeah, I think I have two issues. I don't necessarily disagree with Mr. Joe. It's just, we have to admit that the language is really not clear enough. However, reading this again, it does say that we are to promptly dismiss the complaint. It does say that, but it promptly in the legal field is like all deliberate speed. when they desegregated the schools in Brown versus Board of Education. So, but we're not a judicial body, so we could take a vote on that. However, I'll say this and we come back. The second allegation in the complaint has to do with the city attorney's conduct in representing her husband. That's separate and apart by my reading.
It is.
It may be, right, there may be some animus motivated by that.
Go ahead.
Right, so that to me, and we can vote on that. That to me, in my opinion, would seem like, I think we'd be okay if we promptly dismissed this complaint. If we thought as a body, promptly means immediately. I think I'd be okay with that. But the second part of the complaint, I say, is a complaint where it's alleged by citizens that this person, a city official, violated this code section by representing her husband. I think at that point in time, it has to go to a preliminary hearing. They have to have 10 days notice.
I totally agree, because I feel like the amendment can go for the first one, but for the second one, that,
Right.
and you can't. There's nowhere in here that says we
Yeah.
can bifurcate them.
Right.
You like
I don't see
bifurcate
that. Right.
claims?
I don't see that.
You can't bifurcate
So,
this.
yeah, I could go along with promptly dismissing complaint number one, because I can see where
That takes all
I would suggest to the city, they make the language more clear. But I could see where I think that's what they meant. Right.
Now, what I want to say about that is that I completely agree with everything that is saying that we need clarification, because when I read that, and maybe I read something into it, to me, it stuck out that had nothing to do with this by her representing her husband.
Yeah.
Now, I may be wrong, but that's what I gathered from reading that.
But that was the second charge.
Yeah, this is what I'm saying.
Right, that was the second charge.
But it was not specific as to what she was representing her husband for.
For
Yeah,
improper
it
left
wasn't
turn.
Right.
I didn't read it like that.
There's a plea and abstention,
Right.
and it was for an improper left turn.
Right.
There's a plea, actually, there's two plea and
Right, she
abstentions.
represented him in front of the city body.
Oh, okay,
Right,
okay.
right.
And so
And
that's
she
when,
was the lawyer for her husband.
Well, I
In
misread
front of
it.
the
I
city
thought
court.
it was she represented him for something that wasn't in front of it.
No, yeah, it was in front of the city court, and they have the attachment that showed her entry of appearance.
I stand to be corrected.
Okay, that's okay.
Yeah, and then the judge
This is a lot of
emailed,
information.
the
So-
judge emailed back and said, hey,
Right.
you can't
Right.
do this because you're the attorney
Right,
for the city, and you're also trying, it's a conflict of interest.
Right.
But technically,
Whether or not-
whether or not this against actions arising from court proceedings, or is it about her behavior?
Correct.
So that's your,
right, that makes it, right, it's an issue, right, it's an issue.
Let me recognize Mr. Hodges.
Just a couple of points, and I get into meanings of words and what they actually mean. In my opinion, the amendment is somewhat deficient because it does not define what the preliminary hearing is to be. One could interpret that as us doing exactly what we're doing now. That's one issue that I have.
Mr. Hodges, you're referring to the emergency?
Yes,
Okay.
emergency section C.
And the language which says promptly?
Well, it says, what I'm reading is, within 30 calendar days of the board's receipt of a complaint, the board shall make a determination at a preliminary hearing as to
Oh,
whether
that's
the
the,
complaint should.
that's the ordinance 2018-052.
No,
Right.
this is a regular ordinance. I apologize, I pulled the wrong ordinance.
Okay, that's the
But,
regular ordinance.
On the regular ordinance.
Right,
It fails to define what the preliminary hearing
Right.
actually is. So, number one, do we have the ability to define how we're gonna proceed as a preliminary hearing? What is that going to entail for us
Well,
as a body? That's
yeah,
the first.
right,
Second thing is, in regards to dismissal, as you stated, it says promptly dismissed.
right.
Does dismissal mean you missed the complaint in its entirety, or do we have the ability to strike particular
And
actions
that's what-
within the complaint?
Right, and that's what
That's what
I think,
Pope said,
I,
right?
I don't wanna put the cart before the horse, because I think there's some things we need to decide on how we're gonna operate procedurally, because this is just the first one.
Right.
So we're gonna get more than one, and it's not gonna be drafted by an attorney, it's
Right.
gonna be lay people, and we're gonna have to go through the weeds to figure out what's a viable complaint
Right.
and what's not.
And-
So we need to try and come up with
And-
something to set those
And
standards.
let me say this too, this emergency ordinance is gonna be problematic.
Yeah, I agree.
Because
With
when
the
you
date-
flip the page,
with
it
the date,
says section
yeah,
5,
12 and
effective
11,
date of this
yeah,
ordinance
it's gonna be problematic.
is based upon section 3.18 of the city charter. That is, I can't,
Right, that's not
I'm
our
not a
job.
judge, so that's not our job.
It's,
But I'm
that's the
saying
city
that's gonna
council,
be
yeah,
problematic.
that's their problem.
Yeah.
That was the first thing I
Right.
noticed.
Yeah, that's right, that's not our job.
I paid
Right.
attention
Yeah,
to
but that's
that.
gonna be problematic. So,
I think you were on your
you know, I'd be okay, yeah, so the bifurcation issue is silent, but I think complaint speaks to each individual. It's like an indictment may have multiple counts.
But just like
Right.
just like a complaint.
Right. You set out each count, right.
Every count.
Well, if
every
you look at
allegation.
it, it could just be like, when you look at a complaint and it'll say, claim for action
Mm-hmm.
number 1,
Mhm.
and then claim for action number 2. Maybe we could treat it like that.
That's what
Right.
And then not bifurcate it, since there's nothing in here about bifurcating it, and just
What does that mean?
splitting it
Splitting
up.
it up.
What are you saying?
Mhm.
Splitting it
What's
up,
the word you use?
bifurcate.
Bifurcate.
Yeah, so it's kind of just like having
Right.
2 claims.
Mm-hmm.
Why just
Well, I
take
think
all
that's a
up?
So-
question. I think
Right,
that's a
and
question.
that's an issue
I
that
think
we
it's a
can decide
question
as a procedure.
that we-
Let's first vote
Right.
on whether we want to bifurcate claims.
I think
Or
that
dismiss
would
a
be a
claim in its
question.
entirety.
I think that would be a
Right.
question whether or not we can,
Can
based
do it.
upon the emergency amendment, separate and label invalid right up front the first part of the claim because it is from a court proceeding. And then proceed with the second complaint, making no judgment whether or not it is a valid ethics complaint or not, but it is worth hearing.
Let me ask this. I thought what I heard as a consensus is that we were open to getting legal advice from an attorney. Do we all agree on that?
Yes.
And if we agree on that, then I'm gonna ask for a motion shortly. But can we then list some of the questions that we would like the attorney to answer? And if,
Well, I'll be willing to make the
Mr.
motion.
Joe, if
Yes.
you could, I knew you could
Yes, ma'am.
formulate this motion.
Yes, very, very, very easily.
We're gonna list them very carefully.
Yes.
I would ask that you be open to friendly amendments, because
Absolutely.
we've been brainstorming here.
Absolutely.
But make your motion.
I
And
make
y'all
a-
know I don't get to vote, so.
I make a motion that we ask the city manager's office to, provide us with legal representation at our meetings in case we do have questions in lieu of the city attorney being in position to do so. Secondly, question to the current ethics complaint. Can we dismiss the first part of the complaint that clearly originated from a court proceeding, which is in contrast to the amendment, the emergency amendment, section 150010, outside proceedings, whether or not we can separate that and acknowledge that that falls within that amendment and that is something that we are not required to hear, and proceed with the second part of the complaint, which speaks to the attorney's behavior in representing her husband.
Do I hear a second?
I'll second.
Okay. It's been moved and properly second. We all heard the motion. Discussion? Hearing none? We ready to
Well,
vote?
maybe just because I'm a lay person, and like you say, maybe the emergency ordinance may be problematic, but I'm just one of these people that once I read something, it's supposed to be factual, then I believe we need to go down that road. Now, as I said before, maybe I misread, the complaints, especially the second one, which I've been straightened out on that. But it still appears to me, this is just to me, that, this, still flows over to the same thing, as far as I'm concerned. But then, you know, hey, I'm just one, but that's my feelings from reading it. Because I'm just a factual person. If it's facts, that's what I want to stick with, is the facts. And maybe, like you said, Mr. Francis, that this may be problematic for us. Okay, but I wanted to say that because that's just my understanding, and I know I'm not an attorney, but I am one of these people, when I read, I like to make sure that it is what I say, what I'm reading, and it is what it states. I go back to facts all the way for me. Yeah.
Any other discussion?
Yeah, I'd like to amend that motion.
Go ahead.
And the second point would be whether or not, based upon the emergency amendment that was put in place on Code of Ethics, the whole complaint should be dismissed, because that is what the council, what the Ethics Committee is torn by, whether or not we can separate it or whether or not it should be dismissed in entirety based upon the emergency, the outside proceedings statute.
Okay. Any other discussion?
Well, I don't know. I didn't want to make it be so pointed. I think we kind of need to get some training wheels on what we're doing. I didn't want it to be so pointed to just this specific situation.
Right.
You know what I mean? I think we need to ask a question in a broad manner. We're intelligent people. We can apply whatever the attorney might come back with. But I think as a general, we need to get some type of general understanding. How are we going to deal with these complaints as they come in? It doesn't need to be so specific. A general question, and then this would be by way of amendment, in regards to complaints. Do we have the authority to move forward on a particular issue raised in a complaint without going forward on another issue raised in a complaint? And I don't disagree with the people here. I think there are sections of this particular complaint that fall outside of our purview. I don't think that's a question. But I also think there is something that is within our purview. And we need to know, if we have that situation, again, can we move forward with what we should be justifiably moving forward with and leave the other at bay?
But the threshold question was whether we
Correct.
can dismiss without a preliminary hearing. We had some unreadiness on that.
I don't know. I'm
So,
okay with that, I think. But yeah, let's get a lawyer to tell us.
Yeah, I think legal advice is what's needed, whether or not, you know, based upon the questions that we presented. You know, again, the amendment is, the motion is open for friendly amendments, but I think it captures, you know, all of our points of view, which is, you know, can we separate, or based upon the, can we separate if there are two issues, and whether or not, based upon the outside proceeding statute, whether or not the whole complaint should be dismissed. So, you know, yes. Oh, I'm sorry. I'm sorry. I shouldn't.
that's okay. We're in the middle
so
of a
used, I
vote
really
right
am,
now,
so.
let me get your comments after we take this vote. Okay, we're gonna vote.
We're voting on now
The motion to hire or get legal counsel,
Mhm.
attorney assistants to, and help us, to advise us, that's the best word, to advise us on whether we can move forward with dismissal without a preliminary hearing, and whether complaints, whether claims within a complaint can be bifurcated, and one can be decided and the other one can move forward or whatever. So that, I think that was the motion, general. So hiring an attorney to get our questions answered. Ready? All in favor of the motion, say aye.
Aye.
Any nays? Okay, the ayes have it, motion carries.
You got one day,
Okay,
me.
just one? Okay, the motion
I mean,
carries.
yeah, I'm in favor of that, that's fine, that can only help us, that can only make this body better. But, you know, we're an independent body, and the rules do not prohibit us. It's almost like if we do take a complaint, and we have a hearing, and we decide, yeah, you violated the first one, you didn't violate the second one. That's bifurcation. I mean, that's a separation of our determination. So I would say that I'd be okay, because there's other language. So I think promptly is put in there to mean jurisdictionally. You immediately get rid of it. I'd be okay with that, even though I wish they go back and fix the language. I'd be okay with that. I would be okay with that. But I wouldn't be okay with not having a preliminary hearing on the second count of the complaint. Because I think it's two separate complaints. Even though you may say, I'm so mad at you about this case, I'm gonna tell them about what you did. If it's a violation, we're here to determine whether it's a violation of this code, regardless of the motivation as to why the person made the charge specifically, unless they have a political motivation to run as a violation of what's here, okay? As long as they don't have that motivation, we don't take that into consideration. It's just, it's a violation on its face, and here's the documentation to prove it. That person gets an opportunity to come in and have 10 minutes to speak to us.
Okay, we voted. I have a procedural organizational question as to how this will proceed, how we will get this information. Will we get it between meetings or at the meeting? What are your thoughts?
And Madam Chair, remember, our time limit is still running if we do have to have a preliminary hearing.
Yeah.
They get 10 days notice
Right.
before we have that by US mail or email.
That's
So
a
we have
valid point.
we have to keep that in mind. So we need to get someone quick and probably meet soon.
Okay. I would like to hear some discussion as to your thoughts on how we would choose the attorney.
How we would choose the attorney?
Well, somebody's got to choose.
Well, I think that's the city manager's office.
Do we want to let the?
Yeah,
okay.
I mean, the attorney doesn't make us any less independent. Again, we just want to be able to ask legal questions and get legal perspective. And, you know, I agree 100% with Mr. Francis. The thing is, it is legal interpretation. We're still appointed to make decisions independently.
So am I hearing that everyone is okay that with the city manager choosing an attorney and proposing or explaining these questions to the attorney?
I would second that motion.
Getting the opinion and distributing it to us.
Well, whoever's handling city business now,
City procurement, yeah, it wouldn't be the.
I would,
besides the city attorney, do we have
Could we-
anybody else?
Can we hear from Mr. Donald as to how he would proceed in this? Is that okay? Tell us how you would proceed on getting us legal advice under these peculiar circumstances.
So usually the city procures third party. We use an independent procurement process to attain those type of services. But what was not clear, it appears you wanted the questions to be asked, but someone to be present. So you would like a written response to your questions, and then someone to also attend the meetings until you make a decision. Is that
Correct.
That's not, okay. So
There are two different answers.
yeah, it's two different.
That's what I thought.
Yeah, he listed a couple of questions
Right.
specifically. I mean, that's what he did list. My thing was just have an attorney here like you normally have at a city council meeting. So when we have questions like we have now, we can just direct it. So
We on the
can
same
get legal
page.
advice.
Okay.
So in that instance, what we would do is acquire a third party. I think the chair mentioned that you go through GMA or one of these other bodies that allow you to procure through the city. And once you attain the service, then you relay the questions which the clerk's office would have in the minutes. They would then provide, I guess, a formal letter to the ethics board in response to your questions. And then either that same attorney or the attorney that's assigned would sit in the attorney's seat and answer questions that you may have as you would go.
Excellent.
What's the time frame for that?
Depends on procurement. If we pull from the state list or GMA, those pre-authorized, I mean, it's maybe 3 to 5 days, you know, or so, yeah.
So we actually have enough time for that?
I believe so, yes, ma'am.
Yes.
I just one other point to make. Under general authority, it looked like this is really loose. As a body, I mean, whether we want, how we set the procedures and the rules, seem like it's up to us as long as it's a fair process.
Right.
That's correct.
So I don't, you know.
Right.
But it'll take us a
we-
while to get some written procedures, and I believe I understand the will of this body to move forward on the complaint that's filed, and then work on our long-term procedures and training. Did I hear that correctly as the consensus?
I guess maybe, that's where I was going when I was saying, you know, in my opinion, these are legal documents, okay? So, when I talk about facts, this is where I was going. Since it's legal, it's factual, and that's where I felt that we should take this. That was just what I was meaning when I was talking about facts.
So,
Now, they can always come back and amend these to clean up the language, but right now, this is what we have to deal with.
Absolutely.
so what I think the issue is with the second part, why they're asking for an attorney for legal interpretation, is because it says this chapter shall not be used
Correct.
to file complaints against actions arising from court proceedings. So I don't even know if this made it to a court proceeding.
We don't.
That's what we're saying, that is,
Yeah.
and you made the point, that it's so loose, that, you know, we really don't have anything else, but it's still the law.
Yeah, I
That's what
don't,
I'm saying.
like subsection, this one, the second part of it, I mean, the second part of the complaint, I don't know if it even made it to a hearing. It doesn't,
Subsection B.
yeah, it doesn't arise from a court proceeding.
No, not the second part.
We don't know if that's court proceeding file.
But this one, the B part of it does, because this was her removal proceeding.
Right. That's clear, yeah, I'm clear on that, right?
This was her removal
Right,
proceeding,
that- yeah.
B, but A, I don't even know if there was a hearing, like, well, there was a hearing. She emailed her and said, have somebody else.
Well, she entered an appearance through
But
the,
then- yeah,
right,
but
so
then she
she's
emailed-
representing them based on, the Georgia bar would say you are that person's lawyer.
Correct.
Right. But
And then
yeah,
she emailed and said, have him show up, or have someone
Right.
else have him, you know,
Right.
get a new
Right.
counsel.
So that, right, that doesn't arise, it's,
Well-
yeah,
See,
it's.
That's the only one,
Yeah.
but the other two, I would agree.
Oh, yeah, clear.
But
I mean,
B-
even if the city hadn't come up with the emergency ordinance, he didn't have an ethics violation based on what happened in court. That's not, the ethics code doesn't cover that. That's what.
It was
right.
her behavior, I can see where it's the issue. You
Right,
can't-
but
Yeah.
the ethics code doesn't cover anything, any of that behavior. So even if they didn't have that emergency motion, the ethics doesn't cover that. So, but the second part, that, in my mind, that's separate.
So if
Well,
we-
whether or not it's separate or not, I mean, I don't think we're arguing or
Mm.
debating the ethics complaint right now.
No, we're not.
No.
Because, I mean, the thing is, when you're talking about somebody's behavior, is that a performance issue? We have to look at intent as well.
There you
Was
go.
it her intent to be deceitful or in some kind
I
of,
agree.
and so, but anyway.
I agree, right.
So, but,
And that's why.
right, correct.
Right.
All
Let
right,
me
so we're on the
ask
same
a
page.
question about time and next meeting. And, I don't know if Mr. Donald knows this. What's a reasonable amount of time to get the information from the attorney? You gotta hire the attorney's gotta get the assignment and write the opinion.
Well, Madam Chair, I would say based upon the timeframes that we have, that we go ahead and we set our meeting. It is the staff's responsibility to work that out or to advise us otherwise, so forth and so on. But based upon the statute, we have to move forward based upon the timeframe that's in the ordinance. You're in charge.
Do I have a suggestion as to when our next meeting should reasonably be, so that it could be productive? We would have information, and can we look at calendars?
I would say next Monday.
The code doesn't require us to meet at any particular set times, am I correct on that?
No.
It's just whenever we set a meeting.
Yeah, because we had 30 days
Correct.
from the 12th.
That's right.
So I would say
So-
And then
next
10
Monday.
days notice. has
Because
to
we
go
gotta
out.
give them 10 days notice if we proceed.
But we can also extend it or
Right,
delay
right.
as we see fit, as we see fit. So, I think the concern is if we were to delay it or extend it, that we be within the time periods to give notices, something along those lines.
I don't think we're quite there yet. I think if, Madam Chair, maybe if we meet a week from now,
Okay.
next Monday maybe,
How are calendars looking for
which is
next
the
Monday?
first.
What day is next
The
Monday?
first. That would give the city manager's office maybe enough time to do what they have to do and get our questions answered.
I'm free as
I
a
don't either.
Mr. City Manager, do you think procurement could get us an attorney and an opinion in that amount of time?
An attorney for sure, an opinion may take longer. The piece would be, I think we could go directly to one of the pre-approved state legal vendors, and we could likely pick one this week. But we would still have to have a contract agreement with them. And so I'd imagine even quickly between attorneys, which many of you are, it's gonna take about 3 days. And so could they attend a meeting a week from now? Possibly, but that's fairly aggressive. But the written opinion, again, I think might take 2 days. So we're still talking about 5 to 7 business days for it all to come together. So a week from today is kind of tough. I
And it's
would,
the 4th.
And it's, I was gonna say that.
Well,
The
if we don't meet
holiday.
on the first, it's gonna be tough.
Yeah, I don't think a written opinion. Everybody is not gonna read a written opinion in the same context, okay? So if a person is here and they can
That's it.
really ask that question, then they can actually understand or tell that attorney, well, I don't quite understand, can you explain that, you know? But in a written thing, you can't do that, it's just written. And it might end up being looser than what we have here.
I kind of agree with that. I mean, for me, as long as we have an attorney here, you know, that well-versed in ethics, that we can ask questions to when we have, you know, issues come up that's not clear.
and I think, Madam Chair, I think we could do both. If it's the will of the body, so you have requested a written opinion as well as someone to staff it. I think we could do both. I think what I am hesitant on is committing that at the time of your meeting, you would also have a written opinion. What I likely could commit to is having a attorney present at your next meeting who would then be contractually obligated to produce a written opinion on these questions. It's just that they may not deliver those questions prior to the meeting. Does that make sense? And so if, I would just ask you to consider that as you pick your date.
Okay. Discussion on those points?
So I just want clarification from the city manager. Are you saying that we could have someone on the first?
I believe so. It would be, you
And I
know,
think he's saying we could have an oral opinion.
Correct. Yeah,
Someone-
which would be
I
fine
mean,
with me.
We want, if we're dealing with an oral opinion, we want somebody who's prepared to give us answers.
Right.
Right.
I mean,
and I think that's my point, is we could, again, they have, so it's as simple as going to the list, having some preliminary calls, finding out who specializes in this type of law, getting them to come to an agreement, and then executing the contract. If we selected them by the 26th, which is Wednesday, our attorney and purchasing office would have to draw up the contract, which I believe they could execute by Friday and have to be in the seat by Monday. They would be equipped to, I mean, it is a fairly simple document, and so they would then have to review it. And I believe that over the weekend and while they're working on this, when they have their letter of intent and all that good stuff, they could prepare, you know, for the meeting. But I do think it would be unrealistic to think that someone in that short a time frame would also have a written opinion, because they'd only be on board
We don't
one
want it anyway.
business day. And so that's my clarification, that is all.
okay. Well, I would say you could ask for a written opinion, but tell them if they just can't do it, they don't want to work 24 hours a day, burning in a midnight oil, which is what I would do. If I got the assignment, I wouldn't sleep until it's done.
Are you
We'll see
stepping
what we-
down, Madam Chair?
No. I'm through practicing. Okay, on the date, do we have consensus on July 1st at 6 o'clock?
At 6.
I just picked 6 o'clock, that's what time
That's
we
fine.
started today. Does that work for everybody? Nobody's leaving town for the holiday?
Not that way.
Not that day. Okay, then let the record reflect that our next meeting will be July 1st, right here in the same room, at 6 o'clock. And we will, the action item will be the pending ethics complaint, and we will hear from the attorney who will be here to brief us on legal issues, and we'll take it from there. Is that good?
That's good.
Okay. Well, I think we're down to public comment, if there's anybody who wants to comment. Seeing none, I'll take a motion to adjourn. Is there a motion to adjourn?
That's 7.
All in
We
favor?
need the first
I
motion.
thought you did make a motion. I'm sorry.
I
Oh, okay.
said I'll accept a motion.
Oh,
to
okay, okay. I guess I'm in a hurry.
Go ahead and make the motion,
Make your
Bill.
motion.
Oh, I'd like to make the motion that we adjourn.
Thank you.
Second.
All in favor? Say aye. Nays? The ayes have it. Thank you very much.
All right, thank you.
Next